Shh. You are Frankie Farias. Mr. Farias, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and/or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and/or a $2,000 fine. What have you guys worked out?
So for he's pleading time served on the DWI, 13 months deferred on the assault conditions.
Okay. This is how you understand this agreement.
I'm sorry.
You have 2 agreements on both of your cases. On the DWI, they've offered you 3 days in jail, credit for the 5 days that you've done. But you need to understand that that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record, they're going to see this. What do you think they're going to do if you smell like alcohol or dope? Right. I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of paper here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose term. So you need to understand, if you don't understand what a firearm is or what a weapon is.
Hold on a second. This is where the hearing takes a dramatic turn. The prosecution is emphasizing the seriousness of the allegation, but the judge immediately reminds everyone of a fundamental principle of American justice. A defendant is presumed innocent unless proven guilty. That's a crucial distinction. What do you think? Should the nature of an accusation influence a fugitive bond decision before any evidence is presented?
You're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. Just, that's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. You understand? For you to complete this successfully, you have to do a Batters Intervention Prevention Program, what's called a BIP class. This is a 15-week, I'm sorry, is it it's 18, right? 18-week class that you have to go to 1 time a week for 8. You don't have to do this. We can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it.
Have attitude, Judge, is just, I mean, I understand, you know, I messed up. I messed up. It's no one's fault but mine. I understand that, you know, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I mean, I understand. I got a DUI and I ended up catching another.
Criminal court. Did you think this was going to be rainbows and gumdrops?
No, I didn't think that. I'm just, you know, it's just.
And here's the thing, though, Mr. Farias, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really
Now we're getting the judge's real reasoning. This isn't just about paperwork or a missed deadline. The court is weighing several factors: prior fugitive history, flight risk, and the severity of the underlying charge. Notice how the judge carefully separates the extradition issue from the actual criminal case. That's a legal nuance many viewers miss, but it could determine whether this defendant spends New Year's with family or behind bars.
You haven't been found guilty yet.
You mean how I'm talking to you right now?
Yes, sir.
I'm telling you what to expect.
And I understand that,
And I'm
but,
telling you how it's going to affect you.
and I understand that.
And I'm telling you that you can't own a gun.
That's fine. No problem.
You can't own any ammunition.
That is fine. No problem whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody, but I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're-
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say you didn't commit a crime,
No,
then
no,
you're not pleading
this
guilty.
isn't like, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it. You know,
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
well, hold on a second. How old is the case? I mean, the case is from 20, it's 510 days old. No, we set the case for trial today.
We'll do that.
That's it. And I'm not here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand, the way I talk to you now is in hopes that you don't pick anything up in the future,
I
because
promise you I haven't.
do you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm
Every-
sure you do.
Same.
But I'm the one that, I am one of those persons that means it when he says it.
I'm gonna hit the pause button.
You
This-
pick up a case in 2020, and now you pick up a case in 2023.
I'm gonna hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you, but what you're pleading guilty
No,
to carries
you're-
with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in concept. If you plead guilty to DWI today, get convicted, which is what you're planning on doing. The second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away, and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well.
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with
Totally.
him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we,
Oh, I'll just set it today because it'll be long enough that we can have a conversation.
so
Wow, that's probably the most important moment of the hearing. The judge essentially tells the defendant, "I'm not refusing bond. I'm questioning whether you'll come back." The discussion shifts from innocence or guilt to accountability and risk. If Connecticut fails to pick him up by Friday, everything changes. Do you agree with the judge's approach, or should the defendant have been released once the original 14-day period expired? Let us know in the comments.
You're welcome.
Who said my name? Yeah.
This is Mr. Wiley, another plea, Your Honor.
it's not a big deal. Good morning, Mr. Wiley.
Good morning, sir.
Mr. Wiley, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in Harris County Jail. How much credit does he have?
71 days.
71 days credit that you already have. You're giving up a lot of rights by entering this agreement. You give up the right to a trial. Right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you're not